Hello, everyone. Welcome to the fourth week of Miscarriage of Justice. Let's just make sure I am recording. We're good to go. Today, we are going to be talking about the unforgiving legal landscape of miscarriages of justice. So, today, we're going to be exploring the challenging landscape of innocence litigation in the United States and why new approaches are desperately needed, right? So, we've kind of discussed so far the fact that there is a problem, and we've discussed how some of those problems manifest when people are incarcerated or when they're going to trial. But the reality of our wrongful convictions in our justice system, it's shocking and it's sobering, right? And the way we deal with it is crucial to understand the scale and the implications of the problem. So some exoneration statistics for you guys. Since 1989, over 3,000 people have been fully exonerated in the United States. But that number is not representative of all the people who should be exonerated, right? These are only the cases we know about. Many, many more are still likely under discovered. On average, there have been about 91 exonerations per year over the past 33 years. So these exonerations have been for all types of crimes, right? From minor offenses to the most serious. Alarmingly, right, this includes defendants who were found guilty of capital offenses. So these individuals were not only wrongfully convicted, but sentenced to death. So the gravity of such an error in our justice system, it can't be understated at all, right? It is one of the most serious breaches of trust by our government. So each of these cases represents a failure of justice that could have resulted in irreversible execution of an innocent person. But that's only the tip of the iceberg, right? A substantial number of innocent people are residing within US prisons today. As I said, the 3,000 plus exonerations, that's likely representing only a fraction of the wrongful conviction cases that exist or cases that included a miscarriage of justice. And many factors are contributing to the difficulty of identifying and rectifying all cases. So we have limited resources for post-conviction investigations. We have legal barriers to presenting new evidence. The passage of time makes evidence harder to uncover, and we'll talk about that some more today. And there are cases where exculpatory evidence, which we discussed last time, has been lost or destroyed in the process over the years, over the process of the interrogation or over the process of the trial process. But there is a very real human cost to this, right? So each exoneration represents years, often decades lost to wrongful imprisonment. So the impact, it extends beyond the wrongfully convicted to their families and communities, right? Consider the cumulative years of freedom loss. So if let's say, considering the 3,000 people that we do know about, if each of those exonerees served an average sentence of 10 years, that's 30,000 years of human life lost to wrongful incarceration. And there are systemic implications here as well. So the wrongful convictions point to deep-seated issues within our criminal legal system that we have stated over and over in the course of the last 3 weeks now. They raise questions about the reliability of eyewitness testimony, about the reliability of forensic science, about the interrogation techniques we use with people. And each exoneration should prompt a reevaluation of the processes that led to that wrongful conviction. But despite that, we exist in kind of a paradoxical space, right? So, despite widespread acknowledgement of this problem, people know that this exists. People know that this is happening. People know because of a story they heard, or a case they learned about, or a loved one that was wrongfully convicted. Our legal system still struggles to address this effectively, right? So the innocence movement, or what is called the innocence movement, has brought these issues to light, but systemic change has been incredibly slow. But that leads us to kind of a critical question, right? So why, in the face of such clear evidence that something is happening, does our system still resist meaningful review of potential wrongful convictions? Now, we've at this point established the scale and significance of wrongful convictions in the United States. And I want to delve deeper into this paradox that we're discussing right now of our current legal landscape. So, despite undeniable evidence, as stated, of innocence in many cases, our criminal legal system often, even you could say, thwarts serious legal review of these convictions. And to understand why that happens, we need to kind of examine the numerous obstacles that stand in the way of a meaningful review. So, as stated, there's this paradox of recognition versus action. And I'm going to supply you guys with a couple supplementary readings where you can really delve into this. Not required, but if this is something that you're interested in, it's available for you to consume. So, as stated, there's widespread recognition of the problem. So, innocence projects, uh, public exonerations, they've garnered a lot of significant media attention. There have been many legal scholars, judges, and practitioners who have acknowledged the reality of wrongful convictions. There is public awareness of convictions that has increased dramatically in the recent years. We have popular media, documentaries, podcasts that have highlighted really high profile cases and highlighted the things that went wrong in those cases. And some jurisdictions in the United States have even established conviction integrity units to review potential wrongful convictions. Despite that, there's like this systematic resistance to review. So, despite this recognition, the legal system often resists any meaningful sort of change. And this resistance manifests in a few ways, right? So, firstly, it manifests in procedural barriers that prioritize finality over accuracy. Finality over accuracy, right? There are limited resources, as stated, for post-conviction review. There is reluctance, really, of some prosecutors to acknowledge some potential errors in the process. And there are some judicial interpretations, so how judges are interpreting the law, that narrow avenues for relief. So any, let's say, conservative, and I don't mean conservative in a political sense, but conservative in the sense of um, sticking very narrowly to the word of the law and not allowing kind of a wiggle room for interpretation, leaves very little avenues of relief, right? And to discuss this point about prioritizing finality over accuracy, the legal system places high value on the finality of convictions, especially when we're talking about criminal law. So, some arguments for finality include preserving the deterrent effect of criminal law. So, going back to CJ 101, what is the purpose of punishment? Deterrence, right? So, preserving the deterrent effect of criminal law. And then conserving judicial resources. Our criminal legal system is already like incredibly overdrawn, incredibly overpopulated. And there is an argument that if we were to have more post-conviction avenues, that would potentially impact judicial resources. So conserving judicial resources. And a third argument for finality is attempting to avoid the erosion of evidence over time. However, while all these arguments have, some meaning, have some weight to them, this emphasis on finality, it can come at the cost of justice for wrongfully convicted individuals. Now, another thing that we see is what we call institutional inertia. So the criminal legal system is incredibly large, incredibly complex, and it is an institution that is really resistant to rapid forms of change. So reforms often face opposition from various stakeholders, right? So law enforcement agencies are concerned about reopening old cases. You have prosecutors who are worried about undermining public confidence in convictions. And you have legislators who are incredibly hesitant to appear, quote unquote, soft on crime, right? And then we have the issue, once again, with resource allocation. So post conviction review is often underfunded compared to initial prosecutions. While a lot of money could go into the process of convicting the person, a lot of resources could go into the process of convicting a person, post conviction review and relief after the fact is underfunded and under resourced. Public defender offices and innocence projects, they really struggle with limited budgets. And this imbalance in the processes and the resources allocated to each process is difficult to thoroughly investigate, makes it incredibly difficult to investigate potential wrongful convictions. And we also see a legal precedent and statutory limitations, right? So court decisions have often, as stated, interpreted laws in ways that restrict post-conviction relief. So legislation like the AEDPA, which we will get into in just a moment, have created additional hurdles for federal habeas review. So habeas corpus, like reviewing cases post-conviction relief using habeas corpus, pardon me. So state level statutes, they often impose strict time limits on introducing new evidence, and that really limits the potential for post-conviction relief. And we also see some cognitive bias in the legal system. So, various cognitive biases can make it incredibly difficult for legal professionals to not only recognize, but to correct their errors. So, we see confirmation bias, so the tendency to seek information that already exists or that conforms to our existing beliefs, belief preservation. So, this reluctance really to change opinions often even in the face of contradictory evidence. And then we see the sunk cost fallacy. So the tendency to continue a course of action because of past investment, right? Because this is how we've always done it in the past. So change becomes difficult in that sense. And we also see what we call the cumulative effect. So these factors that we've discussed so far, they all combine and create a system that, as stated, paradoxically recognizes the problem of wrongful convictions, but simultaneously struggles to address it effectively. So the result is a legal system that often fails to live up to its ideals of fairness and accuracy, right? And we cannot have this discussion without reiterating the human cost of this paradox, right? So innocent individuals remain incarcerated despite evidence that could exonerate them. Victims and their families, they may be denied true justice when the wrong person is convicted. And public confidence in the justice system is then eroded, right? And there are challenges ahead of us if we are going to begin to rectify this. So addressing this paradox, it requires a multifaceted approach. We need legal reforms to remove procedural barriers. We need increased funding for post-conviction review. We need a massive cultural shift within institutional legal institutions to prioritize accuracy over finality. And we need enhanced training for legal professionals to recognize and mitigate their cognitive biases. And now that we've kind of explored this paradoxical nature of our current system, one that recognizes the problems of wrongful convictions but often fails to address it effectively, I want to break down some of the specific obstacles that make meaningful review almost impossible within our current structure. And understanding these barriers is crucial if we hope to overcome them and create a more just system that lives up to its supposed. So the path to correcting wrongful convictions, as we have stated over and over again, has a lot of legal obstacles. And these barriers form what has been called a multi-headed hydra that make it exceedingly difficult to achieve justice for wrongfully convicted individuals. So let's examine some of these obstacles in detail. So firstly, we see appellate preservation requirements. So the definition here are issues must be raised and preserved at trial to be considered on appeal. So any issues, any potential for a miscarriage of justice must be raised and preserved at trial to be considered at the point of appeal. So what is the impact of this? It prevents consideration of issues that are not explicitly raised during trial. It disproportionately affects defendants with ineffective trial counsel. So we've discussed time and time again these issues with ineffective counsel, and this is disproportionately impacting those individuals. An example of this, right, is let's say a crucial piece of evidence might be excluded from appeal consideration if the trial attorney failed to object to its admission during the trial. Cool? So this is our first kind of legal obstacle. Our second legal obstacle is something we call differential review standards. So appellate courts they give significant deterrence to lower court decisions. And the impact of this is that higher courts are often really reluctant to overturn lower court rulings. And this places a really heavy burden on those who appeal these convictions to prove errors, to prove that their errors are not just wrong, but unreasonable. So an example of this, so even if an appeal judge disagrees with a trial court's decision, they may uphold it if it falls within a reasonable range of decisions. And this takes us into like murky waters because we get back into discussions of discretion and what quote unquote reasonable is and what our definition of reasonable is. And we see varying court decisions based on the lack of conceptualization of that sort of definition. Our third legal obstacle is what we call harmless error analysis. So in this instance, courts may uphold convictions even when errors occurred if deemed quote unquote harmless. So the impact of this are that many constitutional violations are excused as not affecting the outcome. But the culmination of these violations, the effect of multiple quote unquote harmless errors, then becomes overlooked, right? So, an example, an improper jury instruction might be deemed harmless if the court believes the evidence of the guilt was overwhelming. So, what may be viewed as being okay in the moment or okay after the fact culminates into multiple violations, constitutional violations. And then we have the limits of habeas corpus. So there are massive restrictions placed on when and how prisoners can challenge their own confinement. And the impact of this, it creates this narrow ground for granting habeas relief, and it creates a complex procedural landscape that can trap unwary petitioners or petitioners who don't have experience or don't have resources. A valid claim might be dismissed because it was raised in a following petition without meeting the stringent requirements for new evidence. So a person may have a valid habeas claim, but because it was raised in not the exact process that is outlined, it might mean that any new evidence or any exculpatory evidence that may aid their case will have to be dismissed. And then we have statutes of limitations, right? So we often hear about statutes of limitations when a person does something and they say, oh, what's the statute of limitation in that instance? But here it has the opposite effect. So there are time limits for filing appeals or post-conviction motions, pardon me. So the impact here, we see potentially valid claims barred due to the passage of time. And this is particularly problematic for innocence claims, as exonerating evidence may take years to discover with changing technology or changing evidentiary structures. And an example that we may consider is a defendant might discover exonerating DNA evidence, but be barred from pressing it or presenting it due to the expired filing deadlines. And then we have the stringent requirements for new evidence, quote unquote. So there is an incredibly high bar for introducing evidence that's not presented at trial. And this makes it incredibly difficult to introduce any newly discovered evidence post-conviction, and it places this massive burden on the defendant and on the defense counsel to explain why this evidence wasn't found earlier. An example of this may be a witness recantation, right? And if a witness recants, that's often viewed skeptically and it may not meet the threshold for new evidence. And then we have the AADPA's restrictive provision. So I mentioned this earlier as being one of the leading factors in this more restrictive legal definition that we're working with. So this is the Anti-Terrorism and Effective Death Penalty Act of 1996. And this act imposed incredibly strict limits on federal habeas review. So from that act, we saw a 1 year filing deadline for federal habeas petitions and a limits on successive petitions, so one petition after the next. And it required federal courts to defer to state court decisions unless they are clearly unreasonable. So an example of this is a federal habeas petition might be dismissed solely because it was filed a day late under this act's strict time limits. And then we have these siloed analyses of claims. So courts often consider each claim of error in isolation rather than a cumulative impact, right? So they consider each claim as one thing rather than looking at the big picture. And this fails to account for the combined effect of multiple errors, right? And it can result in overlooking the full impact of various issues on the fairness of the trial. So in this instance, multiple instances of prosecutorial misconduct might each be deemed individually harmless without considering how their cumulative effect on the trial's fairness. And these obstacles, they create an incredible barrier to meaningful review of criminal convictions, right? They often prioritize procedural technicalities over substantive justice, and it makes it extraordinarily difficult for wrongfully convicted individuals to prove their innocence or to review or receive a fair review of their case, right? And understanding these challenges, again, as we've stated over and over again, is incredibly important as we start considering how we can reform our system to better serve justice. Now that we've examined these legal obstacles, let's consider some additional hurdles that are further complicating the pursuit of justice in these cases. And while these obstacles may appear abstract, their real world impact is significant and measurable. So there have been numerous studies that have empirically demonstrated how these legal barriers are consistently impeding on justice and failing to provide adequate avenues for reviewing innocence claims. So let's kind of look at some of them, right? So there have been multiple studies on wrongful convictions. So the National Registry of Exonerations, they track exonerations in the United States, and they have been doing so since 1989. And as of 2021, they've documented 2,800 exonerations. So it's estimated that these exonerees have lost a combined 25,000 years to wrongful imprisonment. And then we look at the Innocence Project. So the Innocence Project, their statistics say that DNA exonerations have revealed that in 25% of cases, innocent defendants have made incriminating statements or delivered outright confessions or pled guilty. And this highlights how seemingly strong evidence can be misleading. So if we remember last week's case with the Central Park Five and how those teenagers all provided confessions despite being innocent of any crimes, right? So again, seemingly strong evidence has the potential to be misleading if there are instances within the process that create room for a miscarriage of justice. We see research on specific obstacles. So a study by Keith A. Fenley and Michael S. Scott in 2006, they examined 2,000 appellate cases or appellate decisions, pardon me, and found that only 14% of cases resulted in reversal and concluded that appeal courts are more often reluctant to overturn convictions, even in cases with significant errors. And then we revisit this harmless error doctrine. So Jason M. Solomon in 2004 analyzed this application of harmless error in federal court. So we already discussed this, right? This idea that each error is looked at individually, and if it's deemed harmless, they let it go. And Solomon found that courts deemed errors harmless in over 87% of cases. And that suggests that this doctrine is overused and it's potentially masking significant constitutional violations. And then we look at the AEDPA's impact. So, in a study by King, Cheeseman, and Ostrom in 2007, they examined 2,300 non-capital habeas corpus cases, and they found that only 7 cases, that is 0.3%, resulted in a grant of habeas relief. And they concluded that this act has significantly reduced the availability of federal habeas relief. And another issue that we want to see is this time to exoneration. So, research done by the Innocence Project shows that it takes 14 years to exonerate an innocent person. And this lengthy process is often due to the legal obstacles and the limited resources for post-conviction review. And then we look at prosecutorial misconduct. So again, this is from the Innocence Project. They examined 2,400 exonerations, and they found prosecutorial misconduct in 30% of cases. And despite this incredibly high rate, disciplinary action against prosecutors is incredibly rare, and it occurs in almost less than 2% of cases. And then we see ineffective assistance of counsel. So in a 2009 study done by the American Bar Association, they found that 32 states appointed counsel received less than $50 per hour for out-of-court work. So we're seeing inadequate compensation, and that inadequate compensation often leads to subpar legal representation and increases the risk of wrongful convictions. So access to post-conviction DNA testing is also another issue. So this is a study out of the Urban Institute. They did it back in 2012, and they examined this implementation of post-conviction DNA testing and the statutes surrounding DNA testing. And they found really significant variation in access across states. What does that mean? That means there's not like a generalizable rule or a federal rule across these states. So many states have incredibly burdensome requirements that prevent potentially innocent individuals from accessing testing. And another issue that we're seeing, or another study that was done, was by the National Registry of Exonerations, and this was on plea bargains and innocence. They did this report back in 2015, and they found that 15% of exonerees had originally pled guilty to crimes that they did not commit. So this highlights how plea bargain systems can pressure innocent individuals to plead guilty. Again, I'm going to bring us back to the Central Park 5 case and how those teenage boys were given or were presented with these life sentences and were pressured to the point that taking the plea bargain was the better option for them. So plea bargains and the plea bargain system can pressure innocent individuals to plead guilty. And then we see racial disparities in wrongful conviction. So in a study by Gross, Pusili, and Stevens in 2017, they found that Black Americans are 7 times more likely to be wrongfully convicted of murder than their white counterparts. And this indicates the systemic bias that we've talked about time and time again, and how it compounds into obstacles to justice. So this body of empirical evidence, it shows us, it demonstrates that our current legal system has unfortunately consistently failed to provide adequate avenues for reviewing innocence claims. So the obstacles that we've discussed, they're not theoretical, right? This isn't just words on a page. This isn't just concepts that we're discussing, potentials that we're discussing. There are real, measurable impacts on justice systems, right? And on justice outcomes. these studies that we've discussed, they show us that there's an urgent need for systemic reform to address these barriers and again to even begin to improve our ability to identify and correct wrongful convictions. And now that we've kind of examined the empirical evidence highlighting the failings of our current system, I want us to kind of pivot a little bit and turn our attention to the constitutional foundations of innocence protection. Understanding these foundations is crucial to understanding how we move forward. And so while we've discussed obstacles to justice, it is really important to understand that protecting the innocent from wrongful convictions, it's not just like a moral imperative that we're discussing, it's a fundamental principle and it's enshrined in our Constitution. So looking at like core constitutional values, we have the fundamental principle of justice. So the presumption of innocence. It is a cornerstone of our legal system. And this principle is derived from the due process clauses of the Fifth and 14th Amendments. So the Supreme Court has repeatedly emphasized the importance of protecting the innocents. And there's a historical context as well. So the founding fathers were acutely aware of the dangers of wrongful convictions, and many constitutional protections were designed specifically to prevent innocent people from being punished. And there's a quote, a very famous quote from Benjamin Franklin, where he says, quote, it is better 100 guilty persons should escape than one innocent person should suffer, end quote. And there's systemic integrity in place, right? So protecting the innocent is crucial for maintaining the integrity and the legitimacy of the criminal legal process. And wrongful convictions, they undermine public trust in that legal process. So as stated, the Fourth and Fifth Amendment and the Sixth Amendment all have provided us with these constitutional rights. So in the Fourth Amendment, we see protections against unreasonable searches and seizures. And this is specifically relevant to innocence because it excludes legally obtained evidence, which might otherwise lead to wrongful convictions, and it requires probable cause for arrests in order to reduce the risk of innocent people being charged. So this was established in Mapp v. Ohio in 1961. This established the exclusionary rule. And the Fifth Amendment, it provides several protections that we should consider, including the protection against self-incrimination. So this is in order to attempt to reduce the risk of false confessions. And this was established in Miranda v. Arizona in 1966. And this was also the case that established Miranda rights. And we're all, I assume, familiar with Miranda rights just from being exposed to them on television. You have the right to remain silent, everything you say or do can be used against you, et cetera, et cetera. But the Fifth Amendment also guarantees or protects against the right for double jeopardy. So we have the double jeopardy clause to consider, and it prevents repeated prosecutions, which could increase the risk of wrongful convictions. And it also has a due process clause. So this clause ensures fundamental fairness in criminal processes. So this key case was Brady v. Maryland, and it was in 1963, and it requires prosecutors to disclose exculpatory evidence. And then we have the Sixth Amendment. So the Sixth Amendment guarantees, we're 40 minutes in. Let's stop at the Sixth Amendment. And I will make sure that the quiz and the question reflects that we stopped at the Sixth Amendment. And we'll continue next week because I do think that this has gone on long enough and I have kind of hemorrhaged information at you guys for a good while. But again, there are protections that have been implemented from the founding of the Constitution to this point. There are evidence to support that something is amiss in the system. And just a reminder, your choose your own adventure means choose one. So you either choose the multiple choice quiz or you choose the short essay answer. Not both, just one. Let's please make it easier on all of us, right? Your final case study has already been uploaded. You have until August 13th to complete it. Please feel free to reach out to me if you have any questions or you want to talk about the potential case that you're using and whether or not it's appropriate, I'm more than happy to answer and to discuss. And that's going to be it for today, I think. And we will pick up from this point next week and kind of wrap up this this summer semester. Again, please reach out if you have any questions, and thank you so much for listening.